Hello and welcome to Talk Thursday. I'm Maria Ressa. Today is a historic moment. We're in a brief caesura, a pause between an explosive testimony and a Friday that may show us more. Certainly, by Monday, we're heading into the week with a verdict. Joining us today is a man who's looked at how the prosecution has worked. Aurora Representative Sunny Angara, the spokesman for the prosecution. Welcome to Talk
Maria.
Thursday. Good afternoon. Please, and anyone out there on social media, join us, throw in your questions. We're going to start with a key moment, a moment in the testimony yesterday, 2 days ago, when the Chief Justice of the Supreme Court finished his testimony at the Senate impeachment trial and walked out. Let's look at that.
Direktiba ang aking defense panel na i-rest na po ang aking depensa. Total, wala naman silang napatunayang paratang laban sa akin. Maraming salamat po. Pagpalain po tayo ng buong may kapal. And now, the Chief Justice of the Republic of the Philippines wishes to be excused.
If Your Honor, please, respondent in this case had been on the witness stand and testified for more than 3 hours.
Wait a minute.
He's not been discharged. No, I'm not discharging him. I'm making a manifestation. Huh?
Order. We have not discharged the Chief Justice with due respect to him. Counsel for the defense, will you kindly
Yes, Your Honor.
advise your client to return to the witness stand? I respect him as a Chief Justice, but this court must be respected. Quiet.
May I request for there was misunderstanding, Your Honor. May I request even for 1 minute, Your Honor? We'll have him called back, Your Honor.
All right.
I am very sure it is not out of disrespect to the court.
Session suspended for 1 minute. Please let the Chief Justice come back.
Congressman Angara, what did you think
Sergeant Atang.
when you saw this happening?
Well, to be honest, we were as shocked as everyone else, and I was watching it in the prosecution room at our small TV there.
Yes.
And
Actually, if you look at it now, this is him walking outside. So after he left, this is what he looked like when he was walking outside
right,
the hall.
Of course, it was running through our mind. What's he up to? What's
Yes.
he doing? And we realized, that's suicidal. What he's doing. To not undergo cross-examination would be like a killer blow for his case, because then the court could freely dispose with his testimony, because a witness's testimony without the benefit of cross-examination is really not worth very much. The court would be free to disregard it.
Do you think his lawyers knew that?
They claim not to, and I have reason to believe them, because I've been observing them informally, and there have been some occasions when they seem surprised by some of the documents, like when the ombudsman brought out the Anti-Money Laundering Council report. It
Right.
seemed they were very much surprised by that.
When you looked at him on that day, I mean, we can see some of the video now. Did he look sick?
Not very. No. He seemed quite in high spirits and quite confident when he delivered his speech.
Coming out, again, we had one of our reporters, Carmela Fonbuena, was outside taking the pictures along with one of our cameramen. When he walked out, did he say anything about feeling sick or being sick, having to leave immediately because of that? Did anyone say anything?
I have no knowledge of that, but it could have been. I was told. I've been trying to piece together reports from.
Please.
I've talked to some Senate security personnel.
Yes.
It seemed that when they tried to go down the stairs from the executive lounge. There's a stairs at the rear of the session hall,
Yes.
or at the front of the session hall rather, and it seems that he was blocked by the sergeant at arms, Jose Balahadia,
Yes.
and that's when I think there was a voice from behind the Chief Justice who said, parang kailangan na ng may inumin yan or may kainin yan. So that's when I think the health angle kicked in. So that's one account.
Yes, that's certainly what the defense is saying, right? When you heard him, first of all, when you saw him sign a waiver, and then when you heard him demand the same thing from the prosecution, what did you think?
Well, when he said he was signing a waiver and he said, in the name of accountability, of transparency, I'm signing this waiver to all my bank accounts under Republic Act 1405. I'm waiving bank secrecy. Wow, many of us in the room, I was with some other spokespersons and some congressmen, and they were like, wow, that's impressive.
Correct.
It was certainly not something we expected him to do. And when he, maybe 3 sentences later, said that, but if the 188 congressmen don't agree to sign, then I'm not going to make this waiver effective in effect. No? So that's when we realized that well, it's not an unconditional or irrevocable waiver.
Right. For whatever reason, I mean, analysts have said this is a tactic for deflection, but for whatever reason, it seemed to actually resonate with Filipinos. Is this a matter of the pot calling the kettle black? I mean, are the people who are judging him, who are prosecuting him, are they doing something he's doing?
Well, certainly, I think from a public relations standpoint, it was a very astute move, because because on that day, that Tuesday, all the pressure, all the eyes were on the Chief Justice, and by making that, by hurling that challenge, it kind of then the focus kind of widened. And now there's pressure not just on the Chief Justice, but on all the congressmen, on Senator Drilon, and other personalities. So if that was the goal, I think you're right, they were successful.
What was the reaction among the prosecutors?
Well, I remember there was a press conference about 10 minutes later, and most of us said, that's a publicity stunt, and we're not going to fall into that trap.
But regardless of the publicity stunt, corruption is endemic in our country, right? And is this something that resonated among the congressmen and the senators who were there as well?
I think definitely that's what made it resonate among the public, because there's probably that belief, there's a presumption, I think, against most public officials, I think, that they're all corrupt. I think
Yes.
that's the prevailing worldview, which is why it touched the nerve, I think. But then there's also some kind of failure to distinguish between the situation of the Chief Justice
Correct.
and the situation of the congressman. First of all, the congressmen are elected every 3 years.
Yes.
So, and during that election period, we withstand all sorts of brickbats and challenges and taunts, even worse than what the Chief Justice has experienced
Yes.
to date for the last 5 months. So I think there's a difference, and that's why many legal experts say that when you impeach members of the judiciary who are unelected, in a way there's a higher standard of behavior expected from the unelected.
Correct. Like, you are a very young politician. I guess from what you've seen, how have you dealt with corruption? How do you intend to move forward? What does this mean for you?
Well, I think there's a long way to go. We have the laws. We have very good laws. I've learned. I've attended some conventions. I attended the UN Convention Against Corruption in Bali a few years ago.
Yes.
And ironically, they say that the Philippines has some of the best laws
Yes.
for corruption, but some of them are observed in the breach rather than than on a regular basis. And I think the SAL-N issue is a prime example of that, because it only really hits the headlines when there's an alleged breach of the SAL-N. But I don't think journalists on a regular basis or the public on a regular basis makes it a point to see if these statement of assets
It's true.
are
But certainly,
truthful.
I think that would
Yeah.
probably change
Yeah.
now, right?
I
Would
think
definitely-
I hope so, because that's the intention really of the statement of assets and liabilities requirement. It's meant to be a gauge, and many people say it's unreliable, but it is a starting point nonetheless.
Yes. A question coming in from @Makias Ma'am. Do you think his emotional testimony is likely to help or harm Corona's case?
Well, I think whatever he said or whatever benefit he might have gained in that 3.5 hour prepared statement, I think he lost it. He lost that goodwill when he left the impeachment court. Because the court bent over backwards to accommodate this lengthy testimony. It's in a sense it's very irregular. It's a departure definitely from regular court procedure where you're not allowed to read, and yet for 3 hours he was reading because the idea is for testimony to be from a witness's memory, to be spontaneous. That's part of the judge's job, is to see the demeanor of the witness. Is he answering spontaneously?
Yes.
Did he pause before he answered? Is he consistent in his statements from minute 1 to minute 10? But yet here for 3.5 hours he was just reading a prepared statement. So in that sense they were very generous to the Chief Justice, probably in recognition of his stature, and to give him as much leeway to tell his story.
Well, his lawyer now says that he will attend on Friday, tomorrow. What will the prosecution do?
Well, one part of us says that, wow, what's he gonna say? He could. It seemed to be our advantage if he didn't show up. But then another part of us, of the team, or another part of me says that it's good for the process. It's good to hear him out and to put the closure so that no one can say that he was not given his day in court.
Congressman Neil Tupas said that it was okay for the prosecution not to do cross-examination. What was behind that? And if you're given the option now, which you may have tomorrow, will the prosecution do cross?
Well, from a legal standpoint, we took a second look at the statement of the Chief Justice. It's been reduced. It's been printed by the Records Department, the Journal of Senate, and we looked it over, and it's not that strong, really, from a legal standpoint. No, I think it was mainly addressed towards public opinion, towards gaining sympathy, towards making him appear sympathetic. But looking it over, there's a few things we would have wanted to ask him, but we're willing to forego those, really, in the interest of moving forward. And we feel that even if that testimony or statement is allowed to stay on the record, if you pit it against all the evidence we presented over the last 5 months, we think we've built a strong case because, well, first of all, there's in law, I think documentary testimony supported with oral testimony is much stronger than an unsupported oral testimony, which is in a sense self-serving, and not only self-serving but also uncorroborated by documents, uncorroborated by other witnesses' testimony, like when he says he's been buying dollars since the 1960s. It's so easy to present maybe a bank document or a bank record or what have you, I don't know.
Well, we actually looked at that in Rappler, and we found that not just the exchange rate, but also what he was doing at that time period didn't didn't match the statement.
Yes, I guess that's why people also say that oral testimony is not as strong as documentary testimony because of the unreliability of memory.
Yes.
So,
but he made 2 points that seemed, at least that could help to bolster his case. One is that he decided not to declare his dollar accounts. He admitted he had dollar accounts, and he decided not to declare them because it was protected. And then the second one is that he also decided not to declare his peso accounts because they were commingled, in his words. What do you make of these two arguments?
Well, again, you have it's not supported by any other documents other than his say-so, which in a court of law would really appear very self-serving. Regarding the dollar accounts, he never denied that the information he never said that the AMLAC report is a fake.
Yes, he did say though that
what he said is he doesn't have 82 accounts, and but even if you reduce it to 4 accounts, if you try to tally the balances, they're still way past what he declared in his statement of assets. So I think his attempt to claim the foreign currency deposit law as an exception to the SAL-N law is really a last-minute attempt at creative lawyering to sort of put a semblance of kind of like, oh, I didn't know what I was doing, kind of like it's a good faith defense kind of argument. It's not impeachable. But it's the first time that I've heard that argument ever been made. There's no case. It's the first time that you use a statute that's meant to protect foreign depositors to exempt public officials which is a requirement found in the Constitution and under
Yes.
many laws.
Some analysts have actually said that that would be one of the points against the Chief Justice, is that he should be the one maintaining it. Let me ask you about AMLAC. It also seemed like in his testimony, in his narrative, he was laying the groundwork to basically throw it out because it was, in his words, polluted. Is this a possibility?
Again, that's a self-serving assertion, because I think the members of the Anti-Money Laundering Council, I heard the insurance commissioner, Mr. Doak, say that's really a report that came from the AMLAC.
But it is legal. I mean, it could be admissible in court.
Sure, because under the rules of court, any official records of a government agency are exceptions to the hearsay rule.
Yes.
So that definitely falls squarely within that exception. No?
A question from @myommy. My oh my. Congressman Angara, did you see real panic in the defense team when CJ walked out?
You know what? Things were too hectic for me to even observe. I'd have to go back to the video to see. And I, like I said, I don't know whether I should believe them or not. But then again, I have no reason to disbelieve them, because in the past there did seem to be some occasions where it seemed like he was not disclosing everything to his lawyers.
They also said that he didn't attend a rehearsal on Sunday, so they didn't seem to know what he was going to actually say.
I appeared on a morning show with one of his lawyers, and they said they all gave their inputs as to what was going to that statement, but they never saw the final product. So that final product that the CJ delivered was a mixture of lawyerly inputs and his own inputs, and maybe some other inputs from maybe some writers.
So the inputs, and then
they never saw the final product.
Tomorrow, and then moving forward, what is next?
Well, tomorrow, I think it's his last shot at redemption, and it's up to him. It's within his power to claim it, and the ball is really in his court. I think we're ready with our questions, and then of course we will calibrate how we will strategize tomorrow, depending on his physical condition. Obviously, we'll be cognizant of that.
Here's an interesting question from @Mashes Ma'am. Do you see the issues brought up re dollar secrecy law influencing change in the Philippine banking laws? That's interesting, actually, because it did show up. Something that was used for foreigners now being used by a public official.
Well, it could be the impetus for some possible amendments, because that's a decree or a law that was passed in the 70s. So
Yes.
it's 40 years old, and in the 70s we really wanted to protect bank deposits because there was capital flight at that time, and now we have surpluses, etc. So things have changed, definitely, and you don't want to put dollar deposits on a higher plane than peso deposits.
Correct.
Obviously you want to promote your own currency, and secondly, you don't want to encourage grafters to put their money in dollar deposits in order to evade provisions of the law. So
Technically, if the logic works, then if you were a lawmaker, you could actually just put everything in dollars and not declare
yes,
anything, correct?
that's kind of the absurdity. If you push it to its logical extreme, that's the absurd result.
A question from @Natalie Marana. Who will question CJ on the prosecution side tomorrow?
It's still going to be Attorney Mario Bautista. I think he's one of the more senior members of the team. He's been there since the start, and he's really a very, very capable lawyer.
This one is an interesting question. Can you really prove, from @IamJesh, can the prosecution team really prove CJ is guilty of these charges?
I think we have proven it. I think the burden is really on him to prove that all these pieces of evidence are false, or for him to come up with a more compelling story.
I know that you must, on a daily basis, figure out where the judges stand. I don't know whether you could talk about it, but where do you, right now, where do things stand?
Well, we have an informal maybe idea, but
Yes.
it's very unreliable. So,
Yes.
but we think definitely last Tuesday's events where the Chief Justice walked out, definitely that and that coupled with the Ombudsman's testimony those were the things that I think could have swung the greater undecided majority in our favor.
Correct.
May. I use the word may.
Yes. It's been 5 months. During this whole time, you've certainly weathered your share of criticism, both the prosecution and you. I've seen you on Twitter answering questions.
Sure.
What lessons? I mean, the prosecution has been criticized for being overzealous, for being unprepared. What lessons have you learned in this time period?
That's right. We've been criticized for being overzealous or too much of a killer instinct. But then on the other hand, we've been criticized for being unprepared. So it's kind of conflicting, you know. So I guess if you balance it out, then maybe we are doing some things right. Not everything, but some things. But one lesson for us is that, wow, being a spokesperson is much tougher than it looks.
Yes.
You're not just mouthing lines, actually. And and I was elected as a prosecutor and I declined. I said, maybe I should just be a spokesperson. And it seems that it might even be just as tough, if not tougher, a job as being a prosecutor, because you have to have the overview of all the legal arguments.
Correct.
So,
For the legal team, for the prosecution, what lessons do you think what has the prosecution learned in this time period?
well, I think precision of language, both in the court and in the pleadings, is very important. I think when we had Article 2.4 or Paragraph 2.4 of
Yes.
the second article of the Articles of Impeachment disallowed, or
Yes.
we were disallowed from presenting evidence on that. I think that's one of the bigger lessons for us, that you must craft your complaint very precisely.
And just to remind everyone, 2.4 is the
2.4
is the part
is the part where we alleged ill-gotten
wealth
on the part
which
of the
actually
Chief
could lay a
Justice.
predicate for plunder, right? For charges,
Yes,
criminal
yes.
charges
You
of
could,
plunder.
if you present evidence, you might even be able to if you're able to present evidence on ill-gotten wealth in court, then they could even convict for graft and corruption, which is a separate ground for impeachment under the Constitution. But that was disallowed. That's water under the bridge. But definitely, I think the lesson is learned that you have to be precise in your language and precise in your allegations.
But technically, given the AMLAC documents and the ombudsman's testimony, charges could be filed. Could they be filed? I guess that's a question.
They could, but we didn't have the AMLAC report when we drafted the complaint. But if we had that, we might have drafted it in a different manner and with more specificity. We would have alleged the amounts
Yes.
and the movement. But really, at that point, we didn't have that piece of evidence. But you're right. I think when this is all over, I think, well, assuming he is convicted, then definitely I think the ombudsman already gave a hint of that in her testimony, that she might be able to file those charges especially for forfeiture,
Right.
if because there's under the law, if it's manifestly disproportionate to your legitimate sources of income, and definitely you could file that case.
I know you've been asked this several times, but I'm curious. Supporters of the Chief Justice say that he was singled out because he didn't want to dance the tune. He himself said it's because of Hacienda Luisita. He really hit out at a lot of people then. I mean, was this man singled out? Why the Chief Justice of the Supreme Court? This is a...
Well, the Chief Justice there's so many charges against him. There's 8 articles of impeachment. We just chose to pursue 3, but there's so many instances that really we said that's enough.
Yes.
I think the final straw was the TRO in the case of the former president that might have allowed her to leave if the administration did not take a firmer stand. If the Justice Secretary did not take a firm stand. It really would have been a setback in terms of enforcing public accountability and kind of in the movement for good government. It would have been difficult. And of course, as the Chief Justice, he has to take a certain amount of the responsibility. And we've detailed the way he really went out of his way. Really,
Yes.
In a sense, your Chief Justice. I mean, there's a certain statesman-like quality that's expected of you. You're no longer expected to be a politician. You're no longer expected to be the former chief of staff of your boss.
Yes.
I mean, it has happened that although you were appointed by that president, you're expected to transcend that role.
Were you surprised by his testimony this week? I mean, it was very personal on every front, both a personal attack and a personal plea for him and his family. Were you surprised by his diction, his tone, or do you know?
Not
Chief
really.
Justice?
I think it's consistent with the tone he's taken. It's a bit of it is an appeal to emotion. It's partly an appeal to emotion. It's partly an attack. It's. I would have been surprised if he didn't attack the president personally.
What does this mean for the country now?
That's a good question. I think it shouldn't be about personalities. I think it's not just about the Chief Justice. I think because there's the temptation to kind of just rest on your laurels. If you secure the conviction, then you think then we hope everything will be okay. But obviously there's a lot more. There's a lot of institutional corruption, not only in the judiciary but even in Congress. So hopefully, all these sectors who've been who've come alive because of this trial. Hopefully that enthusiasm or passion or zeal for transparency and accountability doesn't just end there.
Yeah, certainly. There's a lot more to be done then in the justice system and did the waiver getting thrown back, did that strike fear in the hearts of our lawmakers? I'm curious.
Did it strike fear? I don't think it was taken too seriously because maybe if he subjected himself to cross-examination, then he would have that moral ascendancy to hurl that challenge. But because it was hurled, or it was done in such a flawed manner, it was preceded by that walkout, then it kind of I think that really took the edge off.
Excellent. Well, you're also in a very unique position. You're a congressman, spokesman for the prosecution, and at the same time, your father is a senator judge. Do you ever discuss this with your father?
I think once or twice we did, sometime in January or February. And I even remember his comment to me, wala naman kayong ebidensya. But this was early on in the trial.
Yes.
But since then, I don't remember any incident where we really discussed it at length or in detail. Yeah.
It would be interesting to sit at your dinner table. Well, thank you so very much for spending time with us.
It's a
there are more
pleasure,
questions on social media. We will forward them to you, and you can actually get in touch with Congressman Angara yourself. His Twitter handle is @SunnyAngara. This is Talk Thursday. Thank you so much for joining us.